Hello and welcome back to Business Law Online. I hope you're keeping up with all the lectures. It's important to do so. Don't save them all towards the end. It's very hard to keep up with this class. There's a lot of material that I cover, and I want you have to do it every week. You have to keep up with it every week. All right, last week we discussed, we got introduced to each other, and we also discussed the different types of courts. And I just want to reiterate that. I think it's important to know. When dealing with different courts, we have a federal court system, just like we have a federal government. That means just like we have a federal government and state government, we also have a federal court system and a state court system. And they handle very different types of claims, very different matters, very different subject matters. For instance, federal courts, I want to reiterate this, I know I went over it last class. Federal courts handle what type of claims? Copyright infringement, patent infringement, claims involving losses at sea, in other words, admiralty claims, antitrust matters. They're also handled in federal court, as are bankruptcy matters. The bankruptcy court is a great court. Federal courts also have exclusive jurisdiction over any claim in which the United States government is named as a party, either as a plaintiff or a defendant. And the federal court systems have exclusive jurisdiction over any statute where Congress says federal courts have exclusive jurisdiction. An example of that is the 1964 landmark Civil Rights Act. In that act, Congress said that any claim brought under any of its titles have got to be brought in federal court. They can't be brought in state court. Congress doesn't have to say it, but when they do say it, the federal courts have exclusive jurisdiction. Now, state courts are also really important, but they have exclusive jurisdiction over different types of matters. One, domestic relationships, things like matrimonials, family relationships. Those are handled exclusively in state courts. Very important to know. Also, business organizations, for instance, corporations, partnerships, limited liability companies, things like that. When you form those types of business organizations, they're handled if there's any dispute, they are handled in state court. Further, any governance of those institutions, of those business organizations, are handled in state court. So, for instance, if partners have a dispute in a partnership, that would go to state court. Now, also land matters, issues involving land use. That's exclusively state court. Most environmental claims are also handled in state court. Not necessarily, but most of them de facto are, just like criminal claims. Most criminal claims are actually handled in state court as well. Now, there is some overlapping jurisdiction, provided that it's not an area where one court or another has exclusive jurisdiction. Diversity jurisdiction. That's where the plaintiff is from a different state than the defendant. In that situation, the plaintiff has the choice of bringing the claim in either state or federal court. The idea there was to avoid local prejudice. So diversity jurisdiction. Also federal questions. Any issues arising under the Constitution, for instance, the Bill of Rights, that can be brought in federal court or state court. So that's important to keep in mind. All right. For this lecture, the balance of this lecture, I'm going to be discussing the different phases of litigation. And that's important to know. You should know this. Why? Because the first lecture I mentioned characteristics of the legal system, and one of them was that it was very expensive. And this is one of the reasons why. We're going to go through all the different phases of litigation. And it also goes to your due diligence as a business person, as you're out there in the business world. It is important to document what you've done and why you've done it. That's your due diligence. It's okay if you made a bad decision, as long as you made it for good reasons. That's a defense. what I'm going to go over really goes to due diligence. An example of that I encounter a lot in my practice is I'll consult with a client or potential client, and I'll, at the end of the consultation or somewhere in the middle, I'll say to them, do you have any proof? And they usually get a little bit indignant and say something like, well, don't you believe me? And I say, yeah, I do believe you. But I've also been sitting here with you for an hour or two, and asking probing questions, and I believe you. But I have to prove your case. The jury, they don't know you the way I know you. They have no idea who you are. It's going to be you and the defendant, two complete strangers. The jury's not going to know who's truthful and who's a liar. Most jurors will just say, well, who's got more proof? Who's got more proof of their claim? And that's what this goes to. So briefly, the phases of litigation include the pre-trial phase, and that's probably the biggest phase, the trial phase, and finally the appeals phase. So we're going to go through each one of them. Once we get through the pre-trial phase, it's all downhill. The other phases are relatively short. So the pre-trial phase starts first with the pleadings phase. Now, what's a pleading? A pleading is nothing more than a set of written allegations. Now, the first pleading that's served is served by the plaintiff. They serve a summons and complaint. This is what the plaintiff uses to actually sue the defendant. So the defendant will be at home, there'll be a knock at the door, and a process server will physically hand the defendant a copy of the summons and complaint and say, you've been served. Now, what has to be in the summons and complaint? Well, it's a pleading. Pleadings are allegations, so there are some important allegations that must be in every pleading. First, you have to name all of the parties. All the plaintiffs have to be named, all the defendants have to be named. So, for instance, if I have a client and they're married, and the wife comes to me and says, I was in a motor vehicle accident, I want to sue the other driver. I say, fine. And I find out she's married. I'll say, well, what about your husband? He has a claim. It's known as loss of consortium. Okay. If the husband doesn't sue for that claim, loss of consortium, that's companionship, helping around the house, stuff like that. Then the husband cannot collect. All right, so you got to name all the plaintiffs. Second, you have to name all of the defendants. If you don't name a defendant, you cannot collect against that defendant. So suppose the plaintiff is A and A sues B and C. Fine. It turns out that actually D was the one responsible for A's injuries. Well, since A didn't sue D, the claim is dead. And if the statute of limitations is expired, there's nothing that can be done about it. So that's important to know. So a summons complaint has got to have the names of the parties, all the parties involved. Second, it has to contain allegations of why. Now remember, an allegation is not a fact. It's the facts you intend to prove, what you intend to prove. So it has to contain allegations as to why the defendant is liable for the plaintiff's injuries. Very important. It's got to be there. In other words, what laws did the defendant violate? Second, there has to be allegations of injuries. You have to sustain some kind of injury before you can sue. If you don't, then you cannot sue. A lot of times, I'll consult with someone. They were in a motor vehicle accident, and say it was a really bad accident. And I said, "What kind of treatment have you had?" "Oh, I'm fine. I escaped unscathed." Well, that's a problem. That plaintiff has no personal injury to speak of. Now, there's a property damage claim, but honestly, the insurance companies will handle that through themselves. So you don't really need me unless there's a problem. And most of the times, insurance companies handle it pretty well, pretty quickly. But if the plaintiff walked away from the car accident without sustaining a single injury, that's a problem. That's a big problem. So you have to have allegations of injuries, and just a general allegation of pain and suffering, whatever else may be. Fourth and finally, The complaint must contain a prayer for relief. Yes, a prayer, like you would do in a religious institution. A prayer for relief. You're asking the court for something. Okay, so in New York practice and state practice, it's referred to as a wherefore clause. And in the last paragraph of most complaints will read something like this. Wherefore, plaintiff demands judgment against the defendants in the amount of $5 million. Right, so a wherefore clause or a prayer for relief, as is known in federal practice, must also be contained in the summons and complaint. Now, the summons and complaint is divided by numerical paragraphs, and usually you only have one allegation in each paragraph. So usually it's one sentence, maybe two tops. Excuse me. So the summons complaint is served on the defendant. Now, the defendant has to put in an answer. They just can't let this summons and complaint hang out there. They have to appear and put in an answer. What that means is they get an attorney to do it for them. Okay. Now, the defendant, in the answer, they have to either admit the allegation in the complaint, deny it, or deny knowledge and information sufficient to form a belief as to same. So, for instance, the defendant would, following the plaintiff's complaint, paragraph 1, defendant admits paragraph 1. Fine. Paragraph 2, defendant denies paragraph 2. Fine. Paragraph 3, defendant denies knowledge and information sufficient to form a belief as to same. In other words, I don't know. And that's fine. That's fine. Never admit or deny anything that you're not sure of. If you're not sure of it, you deny knowledge and information sufficient to form a belief. Why is this important? Because you're going to sit down with your attorney and you're going to fill out this answer. Your attorney's going to ask you questions about the complaint and you're going to fill it out. You better know if you know it or not. Now, you always got to make sure that you know it. Right? If you have any doubt, if you're not sure, then you could deny knowledge and information sufficient to form a belief as to same. So that's the answer. The answer also contains defenses, affirmative defenses that the defendant intends to prove at trial. An affirmative defense, for instance, would be the statute of limitations has expired. That's an affirmative defense. There's also affirmative defense of comparative negligence or culpable conduct. That really, it was the plaintiff's actions that caused the injury to the defendant. Those are just some examples of affirmative defenses. There are plenty of affirmative defenses out there to be alleged. Okay. The defendant may actually even believe that not only is the plaintiff liable for the plaintiff's injuries, but the defendant also sustained injuries, and that the plaintiff is actually liable for those injuries. So in essence, the defendant is kind of acting like a plaintiff. Excuse me, my allergies are terrible. Hopefully they'll get better sooner rather than later. In that case, if the defendant believes they were injured by the plaintiff, they can allege a cross-complaint, a counterclaim, basically alleging, hey, I, the defendant, am injured, and the injuries were caused by the plaintiff. Excuse me. So that's the pleadings. Those are the pleadings. And remember, pleadings are nothing more than written allegations. They're not facts. They're only what you intend to prove at trial. Now, the next phase of the pretrial phase is discovery. Very important phase. This is when you start to really develop the facts. You really start to develop proof of the facts. Now, a number of things happen in discovery. First, you have production of documents. Right? So all documents related to the allegations contained in the summons and complaint and the answer must be exchanged by the parties. This is your due diligence. right? If you're being sued for whatever reason, you better make sure that you had documented what you had done. This is your due diligence. Any documents related to the allegations contained in the pleadings have to be exchanged. We don't like Perry Mason moments where there are surprises in court. We don't like that. Not in the legal system. Because we prefer that everyone knows what the other party knows. Right? This is supposed to also help settlement. So documents are exchanged, the production of documents, very important. And that includes all memos, correspondence, emails, I would say text, invoices, calendars, pictures, videos, whatever the case may be. It's all going to be exchanged. So it's not just documents per se, it's also photographic evidence and the like. Usually after the documents are produced, the sides exchange what's known in federal practice as interrogatories and what's known in New York practice as bills of particular. Now, these interrogatories or bills of particular, what they do is they actually expand upon the allegations contained in the summons and complaint and the answer. So now, right, so you've made these allegations in the summons and complaint if you're the plaintiff and the defendant in your answer. Now in the interrogatory, now in the bill of particulars, put forth the proof of those allegations. So you got to write it down, right? The facts. The facts. This document, the interrogatory, the bill of particulars, it amplifies the allegations contained in those pleadings, gives you details. And the more detailed, generally speaking, the better. Okay? Again, that goes to your due diligence. Right? Why are you doing what you're doing, and have you properly documented it? All right. After interrogatories are exchanged, interrogatories, by the way, also include, from the plaintiff's point of view, a detailed recitation of their financial damages. If they were out of work, how much money they lost, medical treatment, rehabilitation, whatever the case may be. If it's a breach of contract claim, how much money was lost, stuff like that. All right, so after the interrogatories are served, then the parties appear for depositions. In New York, they're referred to as examinations before trial. And examinations before trial are formal and informal. They're formal in the sense that there is a court stenographer there, and the plaintiff, who testifies first, is sworn in, and then the defendant is sworn in. So it's formal in that regards. It's informal because they're usually held in the plaintiff's or in one of the attorney's offices. Usually whoever has the biggest office, they host the depositions, they host the examinations before trial. Now what this is, it's an opportunity for instance, the parties to get to know each other's clients. So the first party deposed, the first party examined is the plaintiff. They go first. They started this party. They invited everyone here. They get to go first. The plaintiff will sit down, will be sworn in, and then the defendant's attorneys will get a chance to ask the defendant questions about the allegations contained in the summons and complaint, in any documents that have been produced, in the interrogatory or bills of particulars. Anything related to those documents, the attorney can ask, basically ask any question related to those documents. And the idea is to get a sense of what kind of witness would the plaintiff make. Would they be a good witness, bad witness, sympathetic, unsympathetic, etc. Truthful, liar, stuff like that. After the plaintiff is done, the defendant goes, right? Because they are the ones second listed on the summons and complaint. So the defendant goes, and the plaintiff's attorney has an opportunity to ask the defendant or defendants questions about their claims. Specifically, how the accident happened, or whatever the case may be, how the cause of action arise, stuff like that. Now, depositions are important. Why? Well, it does give each side more information about the other. But more than that, suppose one of the parties becomes unavailable. They die, or maybe they move and they don't tell their attorney where they moved to, they can't be located. Well, you always have that deposition testimony. It's a transcript, and that transcript is evidence. It could be introduced at trial. So you always have that witness's evidence. Now, if it's a personal injury matter, after depositions, the defendant will set up what's known as physical or mental examinations, depending upon what kind of injuries the plaintiff is alleging. Sometimes plaintiffs just allege physical injuries. Sometimes they allege physical and psychological injuries. And what they do is the defendant will send the plaintiff to a doctor and or psychologist, psychiatrist of their choosing to examine the plaintiff. So if the plaintiff is alleging they have a broken wrist, the defendant's attorneys will send the plaintiff to an orthopedist who will perform their own test, review the x-rays or MRIs, whatever diagnostic results are around, and they'll make a report and serve it on the defendant's attorneys, and those reports are exchanged just like all documents in litigation. And the idea is to get a sense of is the plaintiff real, or are they exaggerating their injuries? So that information is exchanged. That's the discovery phase. As you get a sense, discovery is a long process. It can go on for years. As a young associate, I worked on a case where discovery literally went on for 5 years. There was rooms and rooms and boxes of documents after documents. It's time consuming. Of course, when things are time consuming, they're what? Expensive. So just keep that in mind. All right. Now, suppose at the end of discovery, one party or the other decides, you know what? This claim should be dismissed if you're the defendant, or if you're the plaintiff, I deserve judgment. As a matter of fact, I don't need a jury. As a matter of fact, I don't need a judge. It may be that both sides agree to the facts. So if both sides agree to the facts, who decides the facts? The jury. Well, if both sides agree to the facts, do you need a jury? No, you don't. The law might be fairly clear. Maybe both sides agree to the law. There's no issue of law. There's no issue of law. Do you need to argue it in front of a judge? No. So it sounds like you don't need a trial. If that's the case, you can make a pretrial motion to either dismiss the case if you're the defendant, or a pretrial motion for summary judgment. I want judgment if you're the plaintiff. Your argument is basically, Your Honor, there is no issue of fact. There is no issue of law. Give me judgment. It's a pretrial motion. In other words, we don't need a trial. Right? The case is clear. We don't need a trial. Sometimes they're granted, sometimes they're not. It's up to, it's every individual case. So pretrial motions, very important stage of the pretrial phase. Just suppose, you go through discovery and maybe you make pretrial motions. Your pretrial motion is denied. It doesn't mean the court's going to give up on you. What the courts will do is schedule a settlement conference. As a matter of fact, most courts, at least the ones that I've dealt with in New York, they schedule multiple settlement conferences. Courts don't like to have trials. Trials are time consuming. They go on for days, weeks, maybe even months. So courts don't like to have them. They prefer all sides settle. So the court will call both sides in for a settlement conference and try to get both sides to settle the case before trial. And a judge cannot force a party to settle, but they can just try and persuade. So settlement conferences are very important. All right, suppose you've gone through all that. Okay. You've gone through pleadings, discovery, pretrial motions, and settlement conferences. You can't resolve the case. You need a trial. All right, the next phase is to go to trial. Okay, this is where the fun begins. Well, the first phase of the trial phase is, well, you have a trial because you don't agree on anything. If you don't agree on anything, you need a jury to make those decisions for you. So the first thing you have to do is select a jury. Juries are selected, or jurors are selected from a pool of potential jurors. The attorneys get to ask the pool of potential jurors questions, basically trying to ascertain whether or not they can be objective. Usually starts with questions like, do any of you know me, the attorney? Do any of you know my adversary? Because if you know one or the other, then what? Maybe there's an issue of whether or not you can be objective, right? If I had my best friend in the jury pool, they wouldn't be very objective, would they? No, he wouldn't be. Next you ask, have you ever been sued, or have you ever sued? What do you think of what happened? Were you treated fairly? How were you treated by the court? What was the result? Do you think it was fair? If it's a criminal case, have you ever been charged with a crime? Have you ever been prosecuted of a crime? What happened to it? Have you ever been the victim of a crime? What happened to the case? Do you think it was handled fairly? So the jury selection process, very important. The next phase, opening statement. So opening statement is actually number 2. First phase of the trial phase is selecting a jury. The second is opening statement. And each side makes an opening statement. The plaintiff's opening statement is similar to the summons to complaint. The defendant's opening statement is similar to the answer. It's basically what each side intends to prove. After that, well, the defendant's kind of lucky. The defendant can just kind of sit back and relax. They don't have to actually prove anything. It's the plaintiff, after all, who wants something. When you want something, you better prove it. So the plaintiff goes first. The plaintiff puts on his or her case in chief. In other words, all the evidence, all the documents, photographs, video, as well as the witnesses, all the testimony, they go first. Second, and during that, of course, the defendant's attorney has a right to cross-examine all the evidence that the plaintiff puts forward. Second, the defendant goes. Now, the defendant doesn't have to go, but what if the defendant made an allegation of some kind of affirmative defense? What if the defendant put in some kind of counterclaim or cross-complaint? Now they're trying to prove something. Now they want something. So if there's an affirmative defense or a cross-complaint, they have to put on their defendant's case in chief. Again, that's all the evidence, witness testimony that would support what the defendant wants. So they go. After that, basically there's closing arguments. Both sides go and point out their strengths and the other side's weaknesses, his closing arguments. Then the judge gets involved. The judge gives the jury instructions. The judge will read the jury charges, and the judge will advise the jury of the applicable law. This is often where you have appealable errors, right? Because the judge now is telling the jury what the law is. Now remember, you cannot appeal a question of fact. You can only appeal a question of law. And this is where there are usually appealable errors. When you go on appeal, you tell the appeals court, Your Honor, the trial judge got the law wrong when they were instructing the jury. Okay. So you have jury instruction. Then you have jury deliberation. And they go back to a room and they follow the judge's charges. Usually the judge's charges are written out as questions, yes, no, and they have to be responded to yes, no, whatever the case may be. So the jury deliberates, and they come up with a verdict. A verdict is a finding of fact. Now the judge then takes that verdict and enters judgment. In other words, the judge is taking that verdict and turning it into a judgment, turning it into a legal obligation. So the jury determines the facts, they give the judge a verdict, and the judge takes that verdict and converts it to a judgment. That's a legally enforceable obligation. Okay. Now, a judgment is then entered. Now, every once in a while, it does happen where a judge is paying attention and the judge has a preconceived notion of what should happen to this case, how the jury should decide it. But the judge will wait and see what the jury does. Now, if the judge has a really strong opinion and the jury comes to the contrary conclusion, the judge can actually set aside the jury verdict and enter judgment notwithstanding the verdict, at which case the jury is usually very angry. If you're going to do that anyway, then why not have to serve on jury duty, that sort of thing. But every once in a while it does happen. When it does, it's somewhat controversial. Why? Because really it's the jury that should be determining the facts, not the judge. Okay. Now, if you're not happy with the decision at the trial court, you can appeal. We talked about that last class. In a civil case, either side can appeal the trial court's decision. In a criminal case, generally speaking, only the criminal defendant can appeal a jury verdict. Why? Because you can only be tried once for a crime. You cannot be tried twice for a crime under the U.S. Constitution. Very important concept. The party that wishes to appeal has to file a notice of appeal. That's not the appeal brief. It's just a couple of pages basically describing what the case was about and what the appealable issue is. The party that wants to appeal is called the appellant. The party that responds is referred to as the respondent. Okay. The appellant files her brief first. The appellant files her appeals brief first, and then the respondent replies. Each side can also submit reply briefs. Now again, appeals are generally speaking limited to errors of law, and usually that's some kind of improper jury instruction, as I mentioned before. But it could also be that the court admitted prejudicial evidence. All right. So we've gone through this, and the proof of any litigation really comes down to your due diligence. Have you properly documented what you've done and why you've done it? But as you can also tell, the process is a long process and it's time consuming. That's why it's expensive. That's why it's expensive. So there has been a trend as of late to do what's referred to handle civil claims mostly or exclusively in some form of alternative dispute resolution. In other words, instead of doing traditional litigation where you have the pretrial, trial, and appeals phase, instead of doing that, we're going to submit our claim to basically a private judge who's going to decide the matter. This is referred to as alternative dispute resolution. It's been around probably close to 100 years. But I'd say probably in the last 20 years it kind of picked up steam because there was a perception that traditional litigation was too time consuming and too expensive, and litigants wanted a cheaper way of resolving their disputes. Now, right off the bat, keep in mind, traditional litigation is typically not voluntary. A defendant does not want to be in court defending themselves, but they're forced to be there. They're forced to be there by the court. If the defendant does not show up, there can be a judgment entered against them. Alternative dispute resolution is, however, voluntary. You can't force someone to engage in alternative dispute resolution. So both sides have to agree. The two sides have to agree. Let's submit our dispute to some form of alternative dispute resolution. So that's an important distinction right off the bat. Now, the two most important types of alternative dispute resolution, the two most common types, are arbitration and mediation. Oftentimes, they are used interchangeably, and honestly, the definition varies from state to state. I'm going to give you a New York definition. With mediation, the sides agree upon a mediator. The mediator is completely neutral. Mediator has no stake in the game. Mediator doesn't know either side. And the mediator is usually a retired judge. It could be an attorney, though, practicing attorney who does it. But usually it's a retired judge. And the sides submit their claims to the mediator, right? A neutral third party. And basically, they submit all their evidence. And usually, sometimes the sides will even submit a joint statement of evidence, so to speak, to the mediator, things that they agree upon. Now, the mediator will listen to the claims and call both sides into the mediator's office. Both sides make their pitch. Now, the thing about mediation is the mediator can only try and get the sides to settle. The mediator cannot force a settlement. Not at all. In a sense, it's almost like a settlement conference that I referred to earlier. So if you don't like what the mediator is saying, you can get up and walk out. It's not a problem. The mediator cannot issue a judgment against you. Oftentimes, contracts contain mediation clauses. If there's any dispute under the terms of this contract, they'll be mediated. And there are companies that set up mediations. The other form of alternative dispute resolution that's very popular is arbitration. Now, with arbitration, the sides agree, again, to a neutral third party called an arbitrator to resolve their dispute. Now, the arbitrator is a lot more powerful than a mediator. An arbitrator can issue basically a judgment that's enforceable against either party. So you're stuck with what that arbitrator thinks. Some sides like it because they know that once they submit their claim to arbitration, they know it's going to be resolved. And for that reason, some sides don't like it. They prefer mediation. If they don't like what the mediator is saying, they know they can get up and walk out and nothing will happen. But with arbitration, the sides are usually attracted to it because they know that once the claim is submitted to the arbitrator will come up with a binding decision. Binding meaning it is enforceable against both parties. So they know the case is going to be resolved. It's not going to be hanging over their heads for months and years to come, stuff like that. Arbitration is, it works well. The thing too about an arbitrator's decision is it's generally speaking not appealable. You can't appeal an arbitrator's decision. So in a sense, it's even more final than a jury verdict reduced to a judgment. An arbitrator's decision, generally speaking, cannot be appealed. Now, it doesn't mean that the arbitrator can do anything. If the arbitrator gets it wrong, really gets it wrong, then maybe it could be appealed. Or, if you suspect that the arbitrator is not so neutral, then maybe it can be appealed. But generally speaking, the arbitrator's decision is not appealable. They have to get it really completely wrong. Okay. Arbitration clauses are also very common in contracts, especially franchise contracts. I know also in sports contracts for athletes, there's an arbitration clause. The thing, too, I want to mention about alternative dispute resolution is it's private. It's absolutely private. the public doesn't have a right to know. Unlike traditional litigation is very public. Anyone can walk in off the streets and look at court files, go to any of the courtrooms. It's an open court system. It's part of our society. So it's very public. It's very public. So arbitration and mediation, two important forms of alternative dispute resolution. There's also conciliation. Conciliation is like mediation, except you have a conciliator. But the conciliator is not neutral. The conciliator is part of one, is interested in one party or another. I've never heard of anyone using a conciliator. There are also mini trials where the sides will actually put on a mini trial in front of a judge. And the judge can either act as an arbitrator or a mediator, depending upon what the sides agree upon. There's fact-finding. That's when both sides hire a neutral third party to investigate the dispute. And that third party's report becomes a finding of fact, and they send it to both parties. And there's also judicial referees. And that's it's kind of like, that's where a claim is in traditional litigation, but there's a really narrow sub-issue. There's a really narrow issue that, the court doesn't want to deal with. If the parties agree, they could submit it to a judicial referee, and they can, the judicial referee will hold a hearing and render a judgment. That judgment, however, is appealable. So those are different types of alternative dispute resolutions, but really the two big ones you gotta know, arbitration and mediation. Those are the two that you really need to know and you really need to pay attention to. Okay. So let's compare and contrast traditional litigation versus alternative dispute resolution. Well, one, traditional litigation is public, very public. Anyone has a right, like I mentioned before, to walk in off the street, look at any court documents, go to any courtroom that's open, walk in, listen to any trial they want to, any motions they want to, whatever the case may be. It's very public. Alternative dispute resolution, it's private. It's private. No one has a right to look at your submissions to your mediator or your arbitrator. It's completely private. So that's something that parties like about it as well. Traditional litigation is time consuming, goes through pre-trial, trial, and appeals phase. That can go on for years. No problem. It can go on for years. It's time consuming. And it also takes a lot of time. It's a lot of work. In comparison, alternative dispute resolution, if I wanted to arbitrate a claim, I could, and the other side agreed, we could probably get a date with an arbitrator within a month. 6 weeks, tops. Second, the submissions to an arbitrator, pretty brief, not a lot of time put into the submission. It's good and it's bad. We'll talk about that next. So traditional litigation is more time consuming both in how long it takes to resolve the claim and also how much time goes into litigating the claim. Alternative dispute resolution is less time consuming both in terms of resolving the claim and also the time put into the claim. And that's starting to change a little bit. Some arbitrations are becoming remarkably complex and go on for years. So there's even an issue among certain parties, why we arbitrated. We just could have litigated it and, gone to, if it was going to take this much time arbitrating it, we should have litigated it. But in any event, generally speaking, it is less time consuming. So what type of claims are best suited for traditional litigation versus alternative dispute resolution? Well, traditional litigation really does flesh out complex facts. Complex facts means complex claims. So if the claim is complex, a lot of facts, a lot of intricate law, it's probably better in traditional litigation. If it's a simple claim, though, a few facts, relatively straightforward, and the law is basically straightforward, alternative dispute resolution is not bad. Alternative dispute resolution is probably best for simple claims, simple facts, simple law. Another important distinction, traditional litigation is appealable. With ADRs, once the claim is resolved, that's it. You're basically stuck with it unless the third party, arbitrator, mediator, etc., really got it wrong. Really got it wrong. Traditional litigation is far more formal. There's a lot of discovery and evidence and procedure. Alternative dispute resolution is a lot less formal. Not really formal at all. It's usually held in the arbitrator's office or the mediator's office. The evidentiary submissions are just usually agreed upon. So those are some important distinctions to know between traditional litigation and alternative dispute resolution. So, as a business person, suppose you decide that you need to commence litigation, you need to sue somebody. Well, what would be some factors that you would consider before suing somebody? Should you just sue anyone whenever you feel like it, or should you really, make it a smart business decision as well? So these are some factors I want to give you that would help make it a smart business decision. The first, probably most important, is your probability of winning and losing, or winning or losing. When you consult with an attorney, they should never tell you this is a 100% guarantee, one way or the other. They should never say that. But what are the chances? Better than not? Okay. What are the odds of prevailing at trial? So the probability of winning or losing. The amount in dispute. How much money is actually in dispute? I think I had mentioned it a couple of lectures ago. Oftentimes I'll have a client, they'll come in and they'll say, well, I have this claim, and so far it sounds like a good claim, a valid claim, and they'll say something like, and it's $15,000 in dispute. Even for a small, modest claim, a small, modest litigation, you can easily get $15,000 on legal fees, court fees, expert fees, no problem. So the amount in dispute is also another factor to be considered in whether or not to bring a lawsuit or not. Related to that, lawyers' fees, court fees, expert fees, and any other costs associated with it. How much is it? How much is it going to cost you? Very important. Another thing that litigants especially have trouble understanding is you have to be involved with your litigation, and that means you're going to be away from your company, you're going to be away from your business. So loss of time from your company or business, that's very important. Also, your employees may be involved in the litigation, so loss of their time. It's time that you could have been working, making money, but you got to sit there with your attorney, you got to go to court, whatever the case may be. Very important. Kind of related to that, aggravation and psychological cost. When you're an attorney, you sue people, it becomes routine. But for most litigants, it's new and it's nerve-wracking because they don't know what to expect. They lose sleep. So aggravation and psychological costs, very important. Another factor that should be considered, how is it going to affect your relationship with the other party? Very important, especially when it comes to vendors and retailers. Retailers don't like to be sued. And a lot of retailers, for instance, have the attitude from vendors, if you're going to sue us, then obviously you don't want our business. So how is it going to affect your relationship with the other party? If it's not good, you may want to reconsider it. That's something that you have to consider. The amount of prejudgment interest permitted by law. So if you have a potential claim for $100,000, you can collect interest. How much interest? Well, you can collect interest for certain types of claims. How much? Yeah, maybe that's, in other words, it's going to boost up your claim. You can recover more money. Maybe that's a factor to be considered. Um, Another factor to be considered is the unpredictability of the legal system. The fact of the matter is you can take the same exact set of facts, the same litigation, you put it in front of one judge and jury, you get one result. You put it the same facts in front of another judge and jury, you can get a completely different result. So there's a lot of unpredictability. Now this list is by no means exhaustive. You can go on and on and on, come up with your own. You know, that's not a problem. And as a matter of fact, you should. But still, you know, if you have any questions, this is the end of the lecture, but if you have any questions, you know, please email me, and hopefully I will, you know, post this video soon. Bye-bye.